you here.
Yeah, definitely. It's my pleasure. And I'm excited to connect to with all of you also.
It was a wonderful, actually, your lectures. Means that all over the panel discussion was wonderful. Means everybody was
Yeah,
listening.
great,
Yeah.
great, great. Yeah.
We are fortunate to have such people with us who are guiding us, who are
No, no problem.
regarding the medical legal issues.
Yeah, yeah. And I'm
Yes.
told Advocate Mishra has spoken to you a little bit on consent, isn't it? His talk was on
Yeah, yeah.
consent. Yeah,
Last
great. So,
month, he has taken one webinar regarding
okay.
the consent itself, and we are running such a series. Means we are the four candidates of yours. They
Yeah,
will talk about the various aspects of the consents. So
yeah, yeah.
last time ही मीन्स मंचन दास केस के बारे में उन्होंने कॉन्सेंट्रेट किया उस पे उन्होंने काफी हद तक बहुत अच्छे
Great.
से डीपली उस केस को उन्होंने हमें प्रेजेंट
Wonderful, wonderful, wonderful. So we have
किया.
done exactly after having studied the Manchanda case, we have come with this uniform Foxy consent. So it makes sense that the lecture,
Yes, yes. That's why
this talk
I
follows that.
continued this series with that.
Yeah,
Means
yeah.
once he took the Manchandas case, the next I was expecting that you should speak on this topic, so
Great,
that
great, great.
people will get connected
We'll cover that.
about it, and so that the ideas regarding that they will means
Yeah,
more they can get.
we will reiterate what Manchanda has taught us. So that also, as we go along, we'll do that.
Yes, yes, definitely. So I think Prajakta, we can start now. It's
Yes.
7 already. Yeah. And
Okay, ma'am.
आकाश recording start कर दीजिए आप.
Yeah, recording is started, ma'am.
Yeah. Okay then, start.
A very good evening to all of you. On behalf of NIMA Central and NIMA OBGY Central, I, Dr. Prajakta Patil, with my co-coordinator, Dr. Neera, I welcome you all to the 53rd webinar. Today's topic is Uniform Foxy Consent for OBGY Surgeries. We have a very eminent and experienced speaker with us, Dr. Dilip Walke, sir. Welcome, sir. It is my great pleasure to welcome all the honorable dignitaries present here on this virtual dais. I welcome Dr. Kamini Dhiman ma'am, President NIMA OBGY Central, Dr. Priyanka Nakade ma'am, Secretary NIMA OBGY Central, Dr. Vishnu Paune sir, Treasurer NIMA OBGY Central, Dr. Rajesh Utane sir, Convener NIMA OBGY Central. I welcome all the office bearers of NIMA Central and state bodies. I wholeheartedly welcome all the delegates attending today's webinar. So before we start, few instructions. First of all, kindly rename your name according to the name which is written on NIMA OBGY membership registration certificate followed by NIMA OBGY registration number. You have any doubts during the session, kindly raise your hand or you can put your doubts in the chat box and we will take all the doubts at the end of the session. So now let us all seek blessings from Lord Dhanvantari and let's start with the Dhanvantari Stavan. Namami Dhanvantari Madidevam Surasurai Pandita Pada Padmam Loke Jararuk Bhayamrutyunashanam Dhataramisham Vividaushadhinam Shankham Chakram Jalaukam Dadhatam Rutaghatam Charudorvih Chaturvih Sukshma Swachatirutyam Shukapara Vilasana Maulimambhojanetram Kalambodojvalangam Katitata Vilasam Charupitambaradhyam Vande Dhanvantarentam Nikhila Gadamiva Praudhadavagnileelam Praudhadavagnileelam Praudhadavagnileelam. So may Lord Dhanvantari bless us all with good health, success and prosperity always. So I would now like to brief everyone regarding NIMA OBGY agenda. NIMA OBGY, that is National Integrated Medical Association, Obstetrics and Gynecological Society of India, aims to impart education in supporting and protecting the character, status, and interests of integrated medical profession in practitioners of Sri Rog and Prasuti Tantra. NIMA OBGYN is committed to promote services for betterment of health of the community, especially maternal and child health, prevention of ailments and diseases, and their treatment with integrated approach of Indian medicine with modern science. So now moving to the topic for today, uniform Foxy consents for OBGY surgeries. Today's topic is very important. Why it is important? Because 70% of the medico-legal cases are because of taking improper consent or not taking a consent at all. Today we are having a lecture on consent, and if anyone has read yesterday's paper, The Hindu, there was an article written as healthcare providers need to pay greater attention to informed consent. So this topic is now coming in the public limelight, and we should be all aware to do practice without any queries. So it is my immense pleasure to introduce our esteemed speaker for today, Dr. Dilip Walke, sir. Sir is Chairman of Ethics and Medico-Legal Committee, Foxy. Sir is President of Pune OBGY Society. Sir is Consultant at Jupiter Hospital, Baner, and Vital Life Medipoint Hospital. Sir is co-author of Uniform Foxy Consent. Sir is Director of Oosphere Gamete Services. Sir is also an advisory board member of Dr. Pratt Telemedicine Solutions. So with this amazing and inspiring biodata, and we have all heard Sir before in Sushruti also, and we know how amazing his lecture is. So please, Sir, do start with the most amazing and awaited session. Over to you, Sir. Thank you so much.
Thank you. Thank you so much for a kind introduction and the usual questions on webinar. Can you see me and am I audible?
Yes, sir.
Yeah. Now, second thing is, are my slides visible?
Yes.
Just a moment. I'll do a slideshow. So are the slides visible now?
Yes, sir.
Yes, yes, sir. Visible.
So I'll get started. First of all, thanks for having me here. Thanks to NIMA, especially Priyanka, Prajakta, and all the office bearers. I'm really surprised, and I'm happy to know that this is your 53rd webinar. So that only shows how much NIMA is all geared up for sharing knowledge and getting educated and getting awareness about, especially even medico-legal aspects of our practice, which also is a very important part of the practice. Just one thing you mentioned about this being a Sri Rog Sangatna. I mean, I always feel because I have attended your conference, and I at the end of having attended the conference, I felt that you people are not working for Rog. You people are working for Arogya. So I think my suggestion is call yourself as Sri Arogya Sangatna, not Sri Rog Sangatna. This is what I felt that day. I attended the conference for the whole day. And what I actually understood and learned from you all on that day was you people were laying more stress on lifestyle management, diet, and other things, other aspects of the practice, which we allopats don't give that much of importance to. So maybe we can call ourselves as three rogue sangatna, but when it comes to you people, you should call yourself as three arogya sangatna. Then that is going to give you a little more authenticity in the way you manage your patients. So whenever I start my talk, I always start with a disclaimer. The disclaimer for you is that I'm not a lawyer like Advocate Mishra, who heard a month back. I don't have experience of litigation of the several thousands of cases that he actually was involved in litigations. I have got no medical legal books to my credit. My only credibility is that I organized several medical legal conferences when I was the chairman of the Ethics and Medical Legal Committee of Foxy for 3 years from 2007 to 2010. And that's where I met many legal luminaries, many even people like Advocate Jet Malani, Justice M.B. Shah, Justice Kapadia, who were the Chief Justice of India. So I had invited all of them for my conferences, and some of them I became good friends with, and my friendship with them makes me look like a medical legal expert. And the secret of my talks is I listen to them. I nag them till I decode the legal jargons that they use in their talks. And I explain all these legal jargons in a very simple language for all our delegates, and to which I add my tadka of abundant caution. And that's how I deliver my talks. Now, coming back to the topic, before we actually start, and I'm very happy that Advocate Mishra has already taken a talk to on the consent vis-a-vis the Prabha Manchanda case. So you all know that consent is a contract, and he must have given you explanation of what is a valid consent. He must have told you the difference between a real consent and an informed consent. Consent in specific situations like an MTP or PCPNDT, he must have touched upon, and he must have told you that consent, whether it is required or not required in life-saving situations. And also, he must have told you about the legal complications of doing a procedure or treatment without consent. All this in the background of the Prabha Manchanda case, Prabha Manchanda versus Samira Kohli case. Don't worry, as we go along, we will touch upon these points also in my talk, so that we will have a recapitulation of whatever Advocate Mishra must have told you. And you can also ask me questions during the question answer session. Just to recap, you all know that consent, it becomes a valid consent if it is taken from somebody who is more than 18 years of age and not insane. And if the child is less than 18 years of age, then it is the consent of the parents or the guardians which is important. Second point is voluntariness, which means it is the patient who signs the consent. I mean, you cannot be taking consent of the mother-in-law, the father-in-law, or the husband. They are signing merely as witnesses. Life-saving procedures may not require consent. And the immediate important part of consent is knowledge, which means you have to explain the patient about the disease, about the procedure, about the treatment that you are given. So only then it becomes a valid. You cannot be just throwing a piece of paper in front of the patient and say, sign here and do the surgery. You have to back it up with counseling, with giving the knowledge to the patient. And having understood all this, let me take back to the year 2020. It was the COVID times, and during COVID times, the president of Fogsi, then Dr. Alpesh Gandhi from Gujarat, he was a little taken aback by these WhatsApp messages which were floating at that time about consent, pre-printed consent being an unfair trade practice, because there was a national forum judgment which said that if you have a pre-printed consent form, then it is an unfair trade practice, and the compensation that was awarded in that case was to the tune of 10 lakh rupees. So what he did was, our President Alpesh Gandhi called me, Dr. Nikhil Datar, and Dr. MC Patel. These are the medical legal experts of Foxy, and we three of us came together. And on it, everything was on a webinar those days. I mean, nothing could be. We couldn't actually meet in person, and we had a lot of discussions on Zoom platform. And he said that we have to do something about it. The first thing that we wanted to do was we had to convince him that this pre-printed consent form is not an unfair trade practice, because this particular case is presently in the Supreme Court, and there is a stay on this judgment. So this judgment that has come from the National Forum is stayed in the Supreme Court. And Dr. Kantikar, who was one of the judges in the judgment that was given by the National Forum, he had a very in-person communication with him, because he's an orthopedic surgeon, and he moves around. He's a good friend of mine also. So me and the other people, other medical legal experts in Foxy, we had an in-person discussion with him, and he said that he is not. What he meant by that judgment was that he was not against pre-printed consent, but what he wanted to stress was that every consent should be procedure specific, should be patient specific, and all the blanks should be that are there in the pre-printed consent should be filled. All the options that are there have to be struck out, and the correct option has to be mentioned there. So that makes the consent a complete consent. That is what he meant by it being an unfair trade practice. So now we have understood that at least there is no harm in taking a pre-printed consent. Now, having said that, we all worked together and we came out with this uniform Foxy consent for more than 30 OBGYN surgeries, and it is for use in the public domain. So anybody can go on the Foxy website, www.foxy.org, and you can download these uniform Foxy consents for you. These consents are as per the guidelines given by the Supreme Court in the Samira Kohli versus Prabha Manchanda case of 2008. And not only we have done it as per the guideline, because just following the guidelines and making your own consent was not enough. We got them endorsed by one Justice Kaushal Thakkar, who is from the High Court Allahabad, by Justice Ambada Joshi, who is a Lokayukt from Goa, and he was a former High Court judge. We got it endorsed by Advocate Shirish Deshpande, who is a president of a Mumbai Grahak Manch. So we got it endorsed by a consumer also, consumer activist. We got it endorsed by none other than Dr. S.M. Kantikar, who had given that judgment. We got it endorsed by Professor Joga Rao, who's an esteemed teacher in law. And also we got it endorsed by Dr. Anant Rao, who is the head of the department, Maharashtra National Law University. So this consent is something that has been drafted by us, and we don't claim that we have done a wonderful job. We've got it endorsed, and it is still evolving. We can have opinions coming to me on my email, on my phone number, and we can evolve that consent as days pass. So now basically we were concentrating on the knowledge part of it. Our main thrust while drafting the consent was that the Supreme Court told us in that case of Prabha Manchanda versus Samira Kohli, it says that you are supposed to give an outline of the nature of the treatment, the benefit of the treatment, the substantial risk of the treatment, the alternatives of the treatment, and the consequences of the refusal. And you will find out that these were the exact headings which we plan to use in our consent draft. So that only proves that we have drafted our knowledge part of our consent as per the guidelines of the Supreme Court. But before doing that, we were discussing what did the Supreme Court mean by outline. Outline ka matlab kya? Does the Supreme Court say that you have to give information as per the USA standard, which is informing everything? Informed consent, जो पेशेंट को जानना, जो पेशेंट जानना चाहता है, so that becomes informed consent. Or is it that we are supposed to follow the UK standard, wherein it is a balancing what the doctor would want to say, and the doctor would not want to tell that ये surgery करते समय तू मर जाएगी. That is what we do not want to say. But the patient would not want to know everything. So the outline, did it mean the UK standard of informed consent, or the USA standard of informed consent, wherein you inform everything, or a UK standard of balanced real consent? And the second thing that we were discussing is, what is substantial risk? Is the risk more than 2% that is substantial, more than 5% that is substantial, or more than 10% that is substantial? So कौन सी risk बताने का और कौन सी risk नहीं बताने का, this is what we were at a loss while we were discussing about every surgery and every procedure. So when we actually read the judgment, we came to this conclusion ultimately that the Supreme Court does not expect our consent to be a informed consent. I mean, this is something new that you must be hearing, because most of the medical legal experts come and they tell you that you are supposed to take an informed consent. But the fact of the matter is, our Supreme Court does not expect us doctors to take an informed consent. It is supposed to be a real consent. And what is the meaning of real consent? You are not supposed to mention all the remote and theoretical risk of the procedure in such a way that the patient will refuse to do a surgery which is important for her. And also, you are not supposed to mention all the remote theoretical risks of refusal, so that the patient will take up some surgery which was not indicated, not needed also. So we were actually very happy that the Supreme Court is not expecting to us to tell everything to the patient, and we were supposed to take only the real consent. However, having said that, during my personal interaction with some of the legal luminaries and the members of the National Commission, they are all, especially Dr. Kantikar, they are all of this opinion that in this new era of information, even in India, it is prudent to have a complete, detailed, informed consent, especially about the risk. So eventually, whether the Supreme Court has told us that it can be a real consent, actually in practice, our consent is expected to be an informed consent. So what we were doing, we were confused. Kya kare? That is what we were actually, while drafting, this is what we were thinking. कि क्या पूरा लिख देना है? Every little complication are we supposed to write, or it has to be a little something that we do not talk about everything. So in our Foxy uniform consent, what we have tried to do is we have tried to strike a balance between informed consent and real consent, and you will understand how we have done that. So in the consent, what we have done is we have drafted the consent in two parts. One is information part and second is undertaking part. So part one is only information about the different surgeries that we do, and part two is the typical undertaking. The consent हम लोग लेते हैं, I give my consent to this and I have understood about all the complications वगैरह वगैरह जो हम लोग लिखते हैं, that was at the undertaking part number two. Now in the information part, the headings that we have given for every consent goes like this: name of the procedure, meaning of the procedure. It is very easy for us to tell the patient that तुम्हारा मैं hysterectomy करने वाली हूँ, but what is the meaning of hysterectomy? Even that we have explained. Purpose or indication, common list. I mean, while writing the indication, we are saying that this is not a complete list of indication. There can be a very personal indication also. Description of the procedure in simple language, benefits and effects of the procedure, alternatives, like you have to talk about alternatives of cesarean, alternatives of hysterectomy, consequences of refusal, and outline of substantial risk. So these are all the points. The headings are as per Supreme Court guidelines. Information is in a very easy to understand layman's language. If you go on the website and you read it, you will find that the English language that we have used there in the information part is a very simple, easy to understand language. And the Nashik Society has translated it in Marathi. The Hubri Society has done it in Kannada. Somebody will have to translate it in Hindi also. So this is what people have done in Foxy. There is a separate consent for anesthesia and blood transfusion. And the important thing is information of even dreadful complication were drafted in a positive manner. For example, अगर कोई patient आपके पास आती है MTP करने के लिए और वो patient पूछती है कि मैम मेरे MTP करते समय मेरे मरने के chances कितने? Can you say that you've got 0.001% chance of dying on table while I'm doing an MTP? No. That same information has to be given in a very positive way, saying that beta, tere chances of dying on table in a case of MTP, given all the facilities in my hospital, given all the advances in the anesthesia and all the advances in the surgical methodology, is very, very minimal, which means you have not said that it is zero, but at the same time, you have given that information in a positive manner. Just to give you an example, have a look at this very rare conditions for problems of abdominal hysterectomy. I'll read it out for you and you will realize okay, I have included everything in a very positive manner, like allergic reaction to any drug, including anesthesia medicines, blood transfusion, need for assistance for respiration, like oxygen ventilation, shock, stroke, or heart attack due to strain on the heart, fluid collection in the lung, formation of blood clot in the veins, leading to embolus, further leading to damage to vital organs, loss of functions of any limb or organ or paresis, are extremely rare but not unknown complications of every surgery. So the patient is signing all this. So which means in the court of law, it can be proved that you had given an information that such things can happen in any surgery. So सब कुछ हम लोगों ने बता दिया, but in a very positive way. Now, instead of explaining everything, what I thought was I'll just give you an example of the abdominal hysterectomy consent. And this is just to show how we have included everything in the information part: name of the procedure, meaning of the procedure, purpose or indication, description of the procedure. You can go on the website and read all this, but I'm just trying to show you how we have done it while drafting. Benefits and effects of the procedure. Alternative, like for alternatives in abdominal hysterectomy, I have talked about vaginal hysterectomy. I have talked about medical therapy. I have talked of other modes of hysterectomy, other surgical procedure. Like if there is a myoma, then you can talk about myomectomy. So all this has been included. Consequences of refusal, outline of substantial risk, which includes everything like excessive bleeding, infection, injury to surrounding structures. Like there can be injury to the bladder, injury to the ureter. So all this has been explained. Anesthesia. Despite writing about anesthesia here, we are going to take a separate consent for anesthesia also, separate consent for blood transfusion also, and of course the very rare complications I had already mentioned to you as an example. So after having given them the information, then we take the typical undertaking, and the typical undertaking goes like this. And this is the typical consent that we take. But you will actually, when you go on the website and read this consent, you will realize that we have included very important things in this undertaking also. Undertaking, of course, is going to be signed by the patient, and there are going to be witnesses who are going to sign, and eventually the doctor also signs it. Now, I'll tell you some of the important points in the undertaking so that you will realize how we have drafted the consent. Now, before actually going to this second part of undertaking, I have to tell you also, because you people are obstetricians, and it is very important for us that in obstetrics there are certain conditions which come unforeseen. For example, if I ask you, can you 100% predict that the patient will or will not have PPH? Can you 100% predict that the patient will or will not have an amniotic fluid embolism or a pulmonary embolism or a shoulder dystocia and the complications of shoulder? You cannot predict that. So what if suddenly such a thing happens and you have never taken an information consent for that? You have never ever informed the patient about it. How do you tackle that? So what we have done is go on the website. There is a consent called as consent for vaginal delivery. See, there is nothing like normal delivery. There is either a vaginal delivery or there is an abdominal delivery. So we have devised a consent for vaginal delivery wherein we have mentioned all the possible complications of a vaginal delivery. And that consent we take during the antenatal period. During the antenatal period, when the patient is coming for your ANC checkup, that is the time we take that consent. We again take that consent when the patient comes in labor. And if now the patient is going to land, and in that consent, we have also mentioned about the need for cesarean, the need for operative delivery. But then if the patient lands up with an operative delivery, or the patient lands, vaginal the operative vaginal delivery or a cesarean, we then take a special consent for that too. So all this obstetric problem also we have covered in this consent that we have devised for you. So you must go on the and this was the most challenging consent that we thought for us. I mean, it was not proper that only 3 people devised this consent for vaginal delivery. So what I suggest is, you all go on the website, read that consent, and if there are any suggestions, please let us know so that we can make our consent, especially our consent for vaginal delivery, as a robust consent, so that we are actually saved in the court of law. And other thing that I always mention is, everybody should have this habit of conducting pregnancy classes in our practice, and in the antenatal period itself, you should give a about 10 minutes presentation on the unforeseen. And in the unforeseen, you should talk about PPH, you should talk about this amniotic fluid embolism, pulmonary embolism, and all sorts of high risk complications that can occur suddenly in pregnancy. So that this narrative that goes around, no, in the public, दैट डिलीवरी के लिए यंग पेशेंट आई है तो उसको कोई कॉम्प्लिकेशन होना ही नहीं चाहिए. दिस नरेटिव हैज टू चेंज, एंड वी आर टू ब्लेम टू सेट दिस नरेटिव. हम लोग का ही द मिस्टेक इज आस, क्योंकि हम जब भी पेशेंट हमको ओपीडी में पूछता है, मैडम सब कुछ ठीक है ना, द फर्स्ट थिंग दैट वी से, सब कुछ ठीक है बेटा, डर मत, मेरे हॉस्पिटल में आइए ना, अब सब ठीक हो जाएगा. Under the pretext of encouraging the patient, what we are doing is we are setting up a wrong narrative. So we have to set this narrative by actually giving it a form of a consent for vaginal delivery. I just deviated from my topic. We come back to the undertaking, some important points in the undertaking. Additional surgery. Now, what we know and what we believe, and I am sure Advocate Mishra must have told you, as per the Supreme Court judgment, additional surgery in good faith is not allowed unless it is life saving. Because he gave you that example of the Samira Kohli versus Prabha Manchanda, where the scope was put in for surgery for endometriosis. So what was expected was some adhesivolysis, and agar usme koi chocolate cyst tha, so that cyst was to be removed. But it did not give consent for hysterectomy. But the doctor did a consent for took it upon herself and did the hysterectomy in good faith and came out. So this was not allowed. So unless that was a life-saving surgery, like when you put in a scope and you for appendicectomy and found that it was a ruptured ectopic, that you can remove because that is life-saving. But you put in a scope for say for doing some surgery like an appendicectomy, and you found there is an ovarian cyst, you're not supposed to touch that because that is not a life-saving surgery. You're supposed to come out, take a consent for ovarian cystectomy again, and go in. Now, but having said that, have we not in the past? I want all the seniors who are attending today to keep their hand on the heart. Have we not in the past called the relatives like the husband or the father or the mother inside the OT and told them, हे बघा हम लोगों ने सर्जरी शुरू की है, लेकिन देखो हम लोगों ने एक सर्जरी में एक ओवेरियन सिस्ट दिख रहा है और उसका अपेंडिक्स ना बहुत जरा इन्फ्लेम दिख रहा है, हम लोग निकाल देंगे, या एक फाइब्रॉइड है वो हम लोग निकाल देंगे. And the mother or the father or the husband used to give us consent, and nobody questioned us later on in after the surgery. Now all this wisdom of the past is now dying because of the Supreme Court judgment. So what I thought was, can we put in a proxy consent in our consent session? Like you say, the patient gives a consent that I understand that during the course of the surgery, the doctor may find another unanticipated unhealthy condition that may need specific action, procedure, or surgery. And if the doctor feels that it will be beneficial to treat such condition while performing the proposed surgery, and if I am not in the mental or physical capacity to give the consent, the doctor may take necessary decision after discussing it with मिस्टर और मिस और रिलेशन. यानी मेरे हस्बैंड को पूछो या मेरे फादर को पूछो या मेरे ब्रदर को पूछो या मदर को पूछो, and I authorize the above mentioned person to give the proxy consent on my behalf. And the patient may refuse to do also. I mean, patient में से ना मैं किसी को authorize नहीं करती. But if the patient wants to authorize someone, that person can be authorized. That person can be called inside the OT, or you can go outside the OT and tell कि ऐसा ऐसा problem हमें अंदर दिख रहा है. Or in good faith, I would like to do that surgery. It can be done. So we have included that in our Foxy consent. Now, second thing is, when we included this, we thought that the legal luminaries way would say कि ये चलने वाला नहीं है. This is against the law because the Supreme Court judgment says that this is not allowed. There is one judgment, and since there is a judgment, it cannot be done. But to our surprise, all of them, जिनका हम लोगों ने endorsement लिया था, all of them said it is perfectly okay to do such a surgery if you have taken a proxy consent beforehand and if you have taken signature of the person that is there before doing the surgery. So this is what we have included. The second thing is privacy and confidentiality. Now, the moment somebody does a wonderful laparoscopic surgery, afternoon 3 बजे surgery हुआ, 4 बजे खत्म हो गया, 5 बजे WhatsApp message जाता है, and you show everything to all your friends. Now, these kinds of WhatsApp messages where you share the video, where you share the photographs, is actually breach of the privacy and confidentiality of the patient. If for some reason on the social media somebody comes to know the name of the patient जिसका वो video है, either the name is seen on the video itself or the name is when somebody that patient comes to know the name through somebody. So this, if privacy and the confidentiality is breached, then you have done a criminal act against the patient. So what we have done is we have included in the consent, and the patient says that I consent to observing, photographing, or televising of the surgery for medical, scientific or educational purpose, provided my identity is not revealed by picture or by descriptive text accompanying them. So the moment you have taken this consent after the surgery, you can share it with anyone you want to on the social media, provided the identity of the patient is not disclosed, which means the name should not be there, the face should not be seen. So if you do that, I mean, this is the way we have protected many of our Foxy colleagues by taking this point in the undertaking. Point number three is patient-specific consent. So Dr. Kantikar told us that your consent has to be patient-specific. So there, what we have done is we have drafted this, that apart from the above mentioned general information, I have been specifically informed about my individual risk related to X, Y, Z. If she is a cardiac patient or she's got some specific problem, that can be mentioned here and written physically by the doctor, so the patient comes to know that this consent now is a very personal consent for her surgery and not a general consent. So this relates to all the specific problems pertaining to that patient. Now, fourth point is language issue. Now, how to accommodate a patient who does not understand, say, our language? Like in Maharashtra, we know English, Hindi, Marathi. What if a patient from Tamil Nadu comes, and then how do we take a consent? And how will that consent, patient from Tamil Nadu who is not understanding English, Hindi, and Marathi, then how do we take a consent? Then you have to find somebody who is an interpreter, who knows the Tamil language, and then writes it down here, space for the handwritten declaration by the patient or relative or his or her in his or her own language. So she can write here in Tamil that I have been explained the above mentioned by so and so, name of the interpreter, in the language that I have understood. So then now the language issue is also taken care of in the consent. Now, point number five is consent taken for surgery by a specific surgeon under anesthesia by a specific anesthesiologist. But next day, and this usually happens in medical colleges, आपने कंसेंट तो इस सर्जन के नाम पे और इस एनेस्थेटिस्ट के नाम पे लिया और ऑन द नेक्स्ट डे वो सर्जन नहीं कोई और ऑपरेट करता है, वो एनेस्थेटिस्ट नहीं कोई और एनेस्थेटिस्ट एनेस्थेसिया देता है. Now, how to accommodate it? For this, we have a device in the consent that I am aware that the surgery will be carried out under the directions of dash and the team of doctors and nurses and assistants. And I am aware that the anesthesia will be administered under the instructions of dash, name of the anesthetist, and his or her team. So this we include the team rather than an individual. Especially this is important in corporate hospitals or medical colleges. Point number six, very important point, was about jurisdiction. Now, what happens is if the patient from, say, Surat comes to Pune and gets operated here, there was a time initially, as per the Consumer Protection Act, essentially that person had to file a case in Maharashtra only. The file a case in Pune district if he wanted to file in district forum or in Maharashtra state forum. Now the new CPA says that patient can file the case in Surat also or in Gujarat state forum also. So to take care of that, what I did is I drafted a clause saying that I am aware of the grievance redressal mechanism of the hospital. Number one, hospital का एक mechanism है. And I state that in case of litigation in consumer forum, an appropriate forum within whose territorial jurisdiction the hospitals fall into will be approached. तो पेशेंट पहले ही लिख के देता है कि मैं सूरत से हूं, लेकिन अगर कोई प्रॉब्लम हुआ तो आई विल approach the courts in Maharashtra or in Pune. Now, when I drafted this, there was a fight. Like, there were it was a 3 against 1 because Dr. Alpesh Gandhi, Dr. MC Patel, and Dr. Nikhil Datar, they were all against me. I was wanting this point to be put in the draft, and because I vehemently argued, okay, after all, consent is a contract involving finance. This kind of a clause is mentioned in many commercial contracts and even in international contracts. If they are doing it, why can't we do it? But all my co-authors said, they disagreed. They said that here one party, that is the doctor, is in the position to enforce. And this is against the public policy, which is the law of the land, which has been mentioned in the Consumer Protection Act. So all my co-authors disagreed and that's the reason why, though I pleaded कि ये क्लॉज डाल के तो देखते हैं, आई मीन ये क्लॉज डाला है म्हणजे हम लोगों ने क्राइम तो नहीं किया, अगर किसी जज ने ये रिजेक्ट किया तो ठीक है, मगर किसी ने ये एक्सेप्ट किया कर दिया तो देन इट बिकम्स अ केस लॉ and it will help us in the next cases also. However, I lost the flight, and the point was deleted from the uniform Foxy consent. But if you people want it, because when it comes to consent that is endorsed by Foxy, my Foxy friends did not want that point to be included in their consent. But in my personal consent that I am using in my practice, I have included this point also of the jurisdiction. And I'm sure if somebody makes a case against me coming from Surat in Surat, and if I win this point in the court of law, that will become a case law. Uh, uh, so that is what about the jurisdiction. Now, despite such uniform consent, the patient can always say, especially the patient in labor, can always say, if you take a consent during labor, say you took a consent for cesarean when the patient was having pain in labor, the patient can always say that I was suffering and I blindly signed the papers which the nurse gave me. I was given no time to read and understand. Nothing was explained to me. Patient can always say that in the court of law. Even if you have given the information part of the consent a day prior, to read, despite that in the court of law the patient बोलेगा नहीं मुझे 5 मिनट पहले दिया and I had nothing, I had no time to read this information part, and I was given no time to understand what, and that's why this becomes an invalid consent. So how to tackle that? So that's the reason why I mean in the I told you I am on the advisory board of a telemedicine solution app that is called DRPRAC. So what we do is that on that app, we for elective surgeries, what we do is through the app, the patient is registered under you on that app. Through the app, you can send the information part of the consent and the undertaking part of the consent, say 2 to 3 days prior to the elective surgery. से समझो आपको मंडे को हिस्टेक्टमी करना है, आपने आज भेज दिया information part and the undertaking part to the patient, and the patient receives it on the app. Then the patient signs on the Android or the iPhone, you can actually sign it. उस डॉक्यूमेंट को पेशेंट साइन करता है ऑन बोथ द इंफॉर्मेशन एंड द अंडरटेकिंग पार्ट 2 to 3 days prior to the surgery, so that the patient can never claim in the court of law कि मुझे enough time नहीं मिला था ये पढ़ने के लिए. That is stored on the cloud forever. तो वो हम लोगों को कंसेंट का पेपर जिंदगी भर संभालने की जरूरत नहीं. It will be there on the cloud forever. And in emergency cases, of course, you can capture and store the audio or the video clip of counseling on the phone. Like supposing you're going to do a surgery for an ruptured ectopic, तभी हम लोग इमरजेंसी में कंसेंट लेते हैं ना, तभी हम लोग पूरा एक्सप्लेन कर सकते हैं क्या? इट इज इम्पॉसिबल फॉर यू टू एक्सप्लेन everything about the surgery. It is impossible for you to explain everything about the anesthesia. So you can, whatever you tell that, you can always capture it on an audio and a video clip after having taken a permission from the relatives and the patient, and that you can store as an evidence of the counseling that you did for that patient for that emergency surgery. So e-consenting eventually is the way forward for it. And I think organizations like NIMA and organizations like Foxy can come together, because actually drafting that and putting it on the app is a big job, and it's a little costly affair. I'm trying to do it in my own way, but I will need support from all of you. And so if you people are ready to take it upon you, then we can go ahead and let me tell you, if we do it through an app, if you start doing e-consenting, India will be the only country where doctors are taking e-consents. I mean, India will show the way to the whole of the world. So this is nobody all over the world has thought about taking an e-consent like this through an app. Now everything is on the mobile app. So consents can also be taken on the mobile app. So if we do it for our country, it can be done. To end, I'll end with a quiz question. I will post the question here. There are going to be two options. One will be answer A, another will be answer B. So one of the two answers are correct. So you have to select the correct option and send it to me on my WhatsApp number. And my WhatsApp number is 98220385883. I'm giving some time on this slide so that you can note down my WhatsApp number. The first one to give the correct answer will get a prize from my company, Oosphere Gamete Services. The winner will be notified to you by the NIMA during your next presentation. But you have to write down your name and send it as a WhatsApp. Send it on my WhatsApp. Whether the correct answer is A or B, and the first person to give the correct answer is going to get this prize from the company. So the question is like this: according to the ART Regulation Act and the Surrogacy Regulation Act, an Ayush doctor is not allowed to start an ART center, whether it is level 1 IUI center or level 2 IVF center. Your options are A, true, they cannot start, or B, false, they can start. So I'm posting this question to you. Send the WhatsApp to me, and the prize will be announced during the next session. This is my WhatsApp number. Thank you very much for a patient listening. And if there are any questions, I'm ready to take now.
Thank you so much, sir, for such a wonderful session. We have learned so much. It was very specific and informative.
So if there are any
There are
questions,
few
let me know.
questions.
Yeah.
Yes, sir. There are few questions by the listeners.
Yeah.
We'll go one by one. So during ANC, before 18 years and after 18 years, if having any fetal abnormalities, how to proceed with the documentation part, sir?
See, before 18 years, the patient's, the pregnant woman is less than 18 years of age.
Yes, sir.
Okay, you find a pregnant woman less than 18 years of age, the first response, leave aside clinical management, बाद में देखो, सबसे पहले inform the police. I mean, clinical management बाद में मत देखो. When you continue your clinical management, the one thing that you must never forget is informing the police, because this is POXO. If the patient has become pregnant before the age of 18, it only means that she underwent a sexual intercourse before the age of 18, which according to POXO is a crime. So you have to inform the police. Now, whether she was married, she is not married, whether that was a consensual sex or not a consensual sex, whether the boy deserves to be arrested or not arrested, ये सोचना आपका काम नहीं. आपका काम सिर्फ इतना, you inform the police and the police will take care of it. I'll give you another situation also. If the patient is 18 years and 5 months, 18 years or 5 months की patient है, and she comes to you 7 months pregnant. 18 से ज्यादा है वो उसकी उम्र, लेकिन when she became pregnant, she was less than 18 years. This also you have to inform the police. So that is the point number one. Then it is all about sending the patient for sonography, and अगर sonography में congenital malformation है, then as per the MTP Act, you can go ahead and do the termination of pregnancy up to 24 weeks. Now you can do it. I have to stress here, you cannot do it. I mean, you all are Ayush doctors. So whenever I have reiterated this even during the conferences. You being gynecologist, you are allowed to do cesareans, you're allowed to do hysterectomies, you're allowed to do laparoscopies. All that is there because you can prove in the court of law that you have learned that, you have been asked questions on that, and you have been taken viva on that. So if you can prove that in the court of law, you can do all this surgery. But stay away from things like MTP, because there is a specific act which says that MTP is supposed to be performed by the modern medicine doctor. Stay away from PCPNDT Act. You are not supposed to do sonography. So these are certain acts wherein specifically it is mentioned. Now, similarly, because it has now come as a quiz question, I don't want to answer that. I'll give the answer next time.
Yes, sir, sure. So the other question is, after giving a detailed, valid, informed consent, can a patient doubt for the treatment which has been provided by the doctor?
Of course, see, आपने कितना भी अच्छा, see, consent doesn't give you the license to do anything. Like मैंने consent में, like my abdominal hysterectomy consent or any hysterectomy consent mentions about injury to the सराउंडिंग ऑर्गन लाइक इंजुरी टू द यूरेटर, तो मैंने इंजुरी टू यूरेटर का कंसेंट लिया, इसका मतलब ऑपरेट करते समय खचक करके यूरेटर कापू क्या मैं, चलो मैंने कंसेंट लिया है बिंदास, ऐसे कर सकता हूँ क्या? नो. In despite that, if there is injury to the ureter, I will have to defend why in this particular case there was injury to the ureter. Then I'll have to show my defense that there were a lot of adhesions, that there was endometriosis, that the anatomy was distorted, x y z, जो भी मेरा defense रहेगा, which will be there in the operative note, that I'll have to do. I mean, you're not supposed to cause injury to the ureter, but then you'll have to put it as a defense in the court of law why in the first place there was injury to the ureter, number one, and when the ureteric injury happened, then what did I do to manage it, what did I do to prevent it, what did I do when I was expecting it, what did I do to prevent it, like if it was a case of endometriosis, did I involve a urosurgeon in case there was a problem, and what did I do to manage it? That you have to prove in the court of law.
Okay, sir. So in adult pregnancy, mother comes for abortion, requesting not to inform her attendant, her family, instead lie about the conditions. What should be done?
See, there are two answers to this. One is a legal answer, and secondly, social answer. Now, legal answer is the MTP Act gives you full license to do an MTP without anybody else signing. I mean, the consent of the patient is prime. But whenever you're doing, say, you're doing a termination of the pregnancy, right? Now, if you're doing a termination of the pregnancy, essentially it is going to be some surgical method. I mean, if it was an early pregnancy, you will do it with medicine. But if it is advanced pregnancy, you're going to do some surgery. Now, surgery is prone to complication. अगर आपने किसी का कंसेंट लिया नहीं, बाहर कोई फैमिली मेंबर्स बैठा नहीं, और अंदर कॉम्प्लिकेशन हो गया, अब पेशेंट को लाइफ थ्रेटनिंग प्रॉब्लम हो गया, तो व्हाट विल यू डू विद द पेशेंट? वो पेशेंट को खुद उठा के किसी हॉस्पिटल में लेके जाओगे क्या? सो इट इज ऑलवेज बेटर टू हैव समबडी आउटसाइड. टेल हर that I will do it without your husband knowing, without your family knowing, but I will want somebody who could be your friend, who could be your boyfriend, who could be anybody sitting outside to take responsibility if anything goes wrong inside. See, ideally, legally, the person sitting outside is not even supposed to know that she's undergoing an MTP. कॉन्ट्रैक्ट में विटनेस जब साइन करता है, लाइक हम लोग अभी किसी भी कॉन्ट्रैक्ट में साइनिंग एज अ विटनेस, तो वी आर ओनली विटनेस टू द साइनिंग. We are not witness and we are not proxy to all that is mentioned in the agreement. हम विटनेस क्या करते हैं कि मुझे पता मेरे सामने ये डॉक्टर ने इस पेशेंट से साइन लिया, दैट्स ऑल. सो यू कैन टेल द पेशेंट, इवन द विटनेस विल नॉट नो दैट अंडर एमटीपी चल रही है, but some surgery is going on inside, and as a friend he should be waiting outside, he or she should be waiting outside. If something goes wrong, I will need someone to take this patient to a higher institute. That.
Okay, sir. Sir, implied consents can be legally valid?
What consent?
Implied consents.
Implied, of course.
Yes, sir.
There are like supposing a patient comes to a gynecologist and for consultation. Now वो gynec पे पास consultation को आई है, which means it is implied that she is going to be ready for a vaginal examination, right? Gynec problem के लिए आई है, तो which only means that she is ready for a vaginal examination. But अगर आपने as a gynecologist, even as a female gynecologist, vaginal examination तो कर दिया, बाद में PR भी कर दिया और breast भी examine कर दिया. Now, is PR and breast examination included in the implied consent? No, because there you are not expected to do a PR in a gynec setup. So whenever you are planning to do a PR examination or a breast examination, you should take consent of the patient. कि मैं आपकी breast examine करूँ क्या? I'll tell you. See, if I were to ask you कि अगर एक मेल गायनेकोलॉजिस्ट पेशेंट को एग्जामिन कर रहा है तो क्या करना चाहिए उसने? साथ में कौन होना चाहिए?
So वो कंपनी
एक फीमेल अटेंडेंट होनी चाहिए. ये हम लोग मेल के लिए बोलते हैं ना. all the experts will talk about male. I'll tell you incidents of one incident which has happened in Pune city, wherein a female gynecologist, वहां पे one girl came for MTP. She did a per vaginal examination. After doing the per vaginal examination, I don't know for what reason, she also examined the breast of the patient. Now the next day the girl calls this gynecologist, a female gynecologist, She calls this female gynecologist to say that you molested me by examining my breast. So please be careful. When it is implied for whatever reason the patient came to you. It is not implied for other things. So even as a male gynecologist, I do per vaginal examinations maybe without consent. But when I am going to do a any other examination, I take a verbal consent. So there is implied consent, there is verbal consent, and then there is written consent.
So in twin pregnancy, if one fetus is having Down syndrome or other abnormalities, what are the documentation part should be taken care of?
Now you have to document whatever are the sonography reports, the NIPT, and the double marker that you may have done. You document that.
You
You
might
take
be
a
talking about the monochorionic diamnion,
Monochronic,
in which
yeah. This is a very unique kind of a situation, and here I would want you to involve a fetal medicine person. See,
yeah.
as as a as a routine gynecologist, we don't deal with these kinds of cases very often, unless your practice is such that you're doing 100 deliveries in a month. I mean, now, this is not the case for every private practitioner. So if you're and now with IVF pregnancy, these kind of multiple pregnancies are on a rise. So if this kind of a situation comes, then I think it is better to involve a fetal medicine person, do a proper counseling of the patient along with the fetal medicine person, and with the fetal medicine person, you take a proper decision. And if termination is the decision, then you go ahead with the termination. But then
Yeah.
counseling is not just a counseling done by a routine gynecologist. See, there are experts available now, and you take help of those experts and only then go ahead in such cases.
Okay, sir. So if patient is unconscious, what type
Because
of
in
consent?
that patients also, Neera,
Yes,
it
ma'am.
is very difficult to means if the patient is coming in the second trimester and
Yes.
if the other fetus is with the Down syndrome or something like that, to prove means there is no such invasive means non-invasive test that will be prove that the typical or a particular one of them is in the means having a Down syndrome. So in that case, to prove it as it is a twin transfusion syndrome also, this is rather a difficult task, and that should be handled by the fetal medicines itself.
Yeah. It is better to refer them to fetal medicine people. And see, when it comes to Downs now, there is a problem also. I mean, fortunately, this has not been a problem in our country, but there are some countries wherein they say, why should Downs be terminated? I mean,
Yeah.
Down babies are the babies who love their parents much more than a normal baby, and they're as per them, they are cute babies, nice babies, and they have a right to live also. So there is a big lobby which says that you cannot do termination of a Down syndrome baby. Fortunately, in our country, such activists are not there. And if the patient wants a termination, you can do it. So I just wanted everybody to be aware that Downs को इतना lightly लेने की जरूरत नहीं है, because our patients are also coming from USA and you may not know that अपना कौन सा patient maybe of that thinking कि even if it is a Down baby, it is my baby and I want to continue the pregnancy. So don't be judgmental. As soon as the report of Down syndrome comes, don't be judgmental and say, "चलो कल आपके हम लोग terminate कर डालते हैं." No, don't say that. Tell them that this is Down syndrome. Go back, read, have a complete understanding about Down syndrome, and then you take a decision. If you feel that termination करना है, I am there to help you.
So most
Okay.
of the time, yeah, talking about the hysterectomy cases in the perimenopausal woman regarding the removal of the ovaries, most of the times, yeah, it is like means if we find some pathology over there, then we should take the consent first before.
Of course. I mean, hysterectomy consent is not just consent of hysterectomy. It is whether you are going to do oophorectomy or not. That is a very vital part of your consent of hysterectomy. And if you go and read the information part of our consent, you will realize that we have spoken about you losing the estrogens if the ovaries are removed in that consent also. So that is a very important part of our counseling, that if I were to remove your ovaries, you're going to lose that estrogen and we'll have to give you estrogen from outside later on in form of Premarin or something,
Mhm.
if you are doing it in a very young patient. So that also is a very important part of counseling.
And even in the reproductive age for the fertility conserving surgeries, if we found that there is a hydrosulfings or kind of hematosulfings, then in such cases, the prior thing is that we have to means remove the pathology first. Otherwise, unnecessary the problem may arises.
See,
But
what
sometimes,
happens is, Priyanka, what happens is when we are going to put in a scope for, say, a
hmm,
case of infertility,
hmm,
kabhi we don't know whether there's going to be a hydrosalpinx or no.
yeah,
Kabhi we don't know whether the ovary is going to be so bulky that चलो इसको हम लोग ड्रिलिंग करके फायदा होगा या नो नहीं होगा. We don't even know there is going to be adhesiolysis, adhesion.
most of
So
the time.
what I say is, instead, now one of my friends is devising this consent, and that will come on the Foxy website in the uniform Foxy consent of fertility enhancing surgeries. I mean, instead of taking consent for diagnostic laparoscopy alone, you say that I am taking you up for fertility enhancing laparoscopic surgery,
Hmm.
which means then it includes. So what we, in the information part, we will tell them everything. What are those fertility enhancing surgery? One, if there is a hydrosulfings, we are going to remove it. If there is too big an ovary and we feel that drilling is going to help you, then we'll do a drilling. Things like that. So then
Okay.
it will not, it will be a proper consent. So that we are trying to devise now. So all that problem that you are asking also we are going to take care of. But during the 2020 we had less time. We could only devise 30 consents. Now it is evolving. One of my
Yeah.
friends is working on it, and he is a laparoscopic surgeon. So I thought it will be better that a laparoscopic surgeon, and he's an infertilologist also. So I thought it will be better that if he does that consent, and then we will sit as medico legal expert. We'll talk about the language and how to actually draft it. That we will do.
Because counseling that patient in that age where she wants to get conceive and removing her salpinges, then it becomes like a little means it's very means unfortunate for them also, and to
Yeah.
convince them
So
that we are going to remove
it is
this.
very difficult to convince an infertility patient that I'm going to knock off your tubes and I'm
Yeah.
going to send you for an ART treatment. But then now people are well read now. These days they go on the website and they read it. And if you tell them, explain them, ये हाइड्रोसाल्पिंग में जो पानी रहता है वो पानी आपके बच्चे के लिए प्रॉब्लम करेगा. अगर वो इम्प्लांटेशन होगा भी तो अबॉर्शंस होते हैं वगैरह वगैरह, जो whatever knowledge we have, if you
Hmm.
tell them properly, then
Yeah.
they do listen to you. So it is all about sitting with the patient and counseling. That's always there.
Okay, sir. Thank you so much
Thank
for all
you.
the answers you have given us.
Right, thank you very much. And
Sir, I will conduct the thank you speech here.
okay.
On behalf of NIMA
Before you
Obgy.
say thanks to me, I'm saying thanks to you for having invited me.
Thank you, sir. Thank you so much. It's very kind. So, on behalf of NIMA OBGY Society, I would like to express my gratitude to NIMA OBGY Society Central Office Bearers, Dr. Kamini Dhiman ma'am, Dr. Priyanka Nakade ma'am, Dr. Vishnu Bhavne sir, and Dr. Rajesh Utane sir for the guidance and support to conduct today's webinar. I would also like to thank and extend my gratitude to our eminent speaker, Dr. Dilip Palke sir, who took time from the busy schedule and delivered a very knowledgeable and wonderful session with us. Thanks to all NIMA OBGY office barriers. I would also like to thank Mr. Akash Durga Shankar sir and Dr. Priyanka Patil ma'am for all the help and guidance for the technical support. Last but not the least, I would like to thank from bottom of my heart to all the delegates and for the participations. Without all of you, the webinar would have not been possible and successful. Thank you for attending and hope you all have learned and gained immense knowledge from today's speaker. Wish you all a wonderful evening ahead. Now, with due permission of all dignitaries, I am conducting today's webinar. Thank you. Thank you, sir.
Thank you. Thank you so much.
So there are many more questions. We can continue after next webinar.
Next webinar. Next
Yes.
webinar, I'm going to announce the prize. I've got one right answer. I'll tell you. One person has
Okay.
given the right answer. I'll share it with you. The name of the person also.
Okay, sir. Thank you.
Thank you, sir.
Yes, we can conclude now.
Yes.
So thank you, everybody. Thanks for joining. Thank you, RK sir.
Mr. Akash, you can now end the meeting.
Yes, ma'am.